My name is Ben Solomon. I'm the managing partner of Association Law Group. Association Law Group serves as general counsel to hundreds of associations throughout the state of Florida with a primary focus on the collection of assessments. And as everyone here knows, that has been a hot topic and a big problem for associations for many years. It is getting better, but it's still a problem, and it is a moving issue that is constantly changing, not only within the statute and the law, but also in the strategies and techniques of lawyers. And for whatever reason, a lot of lawyers are doing a lot of different things out there. So hopefully this will be informative to you. I'll be glad to take some questions at the end. If I had more time, I'd take them as we go, but I think it'd be productive for me to get through the materials today, and then we can take some questions at the end if that's okay. And I would expect that you will likely learn something hopefully you have not heard before and that you did not know out of the course today. So let's go ahead and get started. And what we're talking about is the collection of past due assessments by the association from owners for both HOA and condo. The laws are very similar, but there are some differences with regards to the amount of time that you have to notice somebody. Statutes are a little bit different, but very parallel in many ways. And the procedure is almost identical. So everything we're going to talk about today would apply to both an HOA and a condo as far as collecting your arrearages. So some of these points are perhaps obvious, others are going to be legal strategy, but overall it is pretty much managing your delinquencies, or I named it today Collections 101 in a nutshell, because these are obviously the basics. And on that note, I want to mention that there is no one way to do this. Your lawyer should be thinking about the circumstances of your case, the situation of the parties to the case, including the bank, importantly. And so we're going over a lot of generalities today, and they all work. But again, I want to emphasize the importance of your lawyer really looking at the details of each matter for you, case by case, and advising you on the legal strategies that fit best for those cases, and not just, so to speak, working in a vacuum and telling you that this is the way it's going to be. So first thing, very obvious one, but you need to get started in the collections process early. Now that seems obvious, but yet we meet with a lot of boards and associations who naturally empathize with the homeowners who are late, and we all do. These are not criminals, these are your neighbors, and a lot of them do face financial hardships, and so a lot of times a board will give them more time, maybe 90 days or even 120 days before they even get started in the collections process. And unfortunately, I'm here to tell you today that generally that is a mistake. And it's a mistake because the legal process itself is inherently slow, time-consuming, and it takes a lot of steps where that owner gets multiple notices, which I'm going to discuss in more detail. And so the problem with empathizing with the owner to the point where you don't get started, is what I'm saying, for a long period of time, is then you're just setting the association back more and more in its goal of getting paid if in fact the owner is going to default in a long-term way where people abandon the property and what have you. And that will just set your lawyer back and the association back even further. And the problem with that is not only the obvious part about not getting your income coming in, but we will talk about a little bit later in the hour how, as you're probably familiar, if a bank should take title to the unit, you have this safe harbor, you're going to be limited in the amount of the assessments you can recover. So every month that goes by is another month of potential losses to your association, which means you need to start quicker. Generally, we recommend, and let me also emphasize, however, that the board can set that policy and procedure. There is no requirement by law as to when you must start your process. You have requirements once you commence as to the time frames that need to be provided, but you don't have to start in a certain time, but you should start prudently and diligently on the file, meaning either have your manager send that initial demand letter or refer it to the attorney as quickly as possible. I generally recommend about 30 days. If the owner is not paid by the 10th day of the month, which is usually your late period, some others use 15 days, they should be notified by management. You may impose your late fee at $25. That gives them ample time for another 20 days after the initial period they had to pay to pay off. And if they haven't done it at that point, again, certainly nothing wrong with the board deciding to perhaps give a second notice or some additional time. But generally speaking, you need to move forward. And so I recommend 30 days. Some boards may opt for 60 days. I certainly do not recommend periods of time in commencement of the action too much later than that. And we do see a lot of boards, and again, it's the natural empathy of the board, which is understandable, but the reality is if the owner's not paying, you need to act on it as quickly as possible. So my first recommendation, of course, is to get started on the collection process early. If your payment is not received by after the certified demand is made, and I'll touch on that for a second. For condominiums, you need to provide them with a certified notice of no less than 30 days before you're entitled by law to file a lien against the property. For HOAs, it is 45 days certified. Now, interestingly, to note on the certified mail, number one, it does not need to be sent by your lawyer. It can be sent by your property manager, and in fact, we recommend that, and let me tell you why. Number one, the manager's probably already sending a late notice. All they need to do is certify that same late notice, and you've already met the first legal requirement of being able to move forward with lien and foreclosure. You've also done another thing. You've saved that homeowner legal fees on that first certified demand letter. Of course, if it goes to the law firm and they send the certified mail for you, and we do that, if that's what the board wants, it's certainly acceptable to do it that way, but then you have a legal fee to contend to. This is already an owner who seems to be having trouble paying in the first place. And I'll be the first to tell you, even as the lawyer, that when you start adding legal fees, we understand you're working in the wrong direction. So it is for expedience reasons, as well as saving the homeowner that extra couple $100 or whatever the amount may be, in maybe having your property manager send the first notice certified mail. Another note on that. The owner does not need to pick up the certified mail to move forward. It simply needs to be mailed certified. Okay, so a lot of times people think, well, did they get it? You're not legally required to confirm receipt, simply to follow the statute as far as mailing it certified. Okay. Now, on a side note, if the unit has changed ownership to a bank or a judicial purchaser or some other party, we then don't recommend it come back down to management to send the certified demand, because typically when you're talking about collections, it should either be with management or with legal, but not with both. And the reason for that is because owners very frequently attempt to circumvent the lawyer to avoid the legal fees once they find out that they have a problem, and that's understandable on their part. The problem with that is if the association accepts the payment but doesn't know what the legal fee was and doesn't collect that legal fee, you now have to pay your lawyer for the legal fees that you otherwise would not have to had paid for if you would have allowed the owner to go directly to the firm. So we do recommend that. So again, if the unit has changed ownership, so originally the demand went out, the lien, maybe a foreclosure, somewhere along the line the unit changed ownership, we certainly do recommend having the lawyer send the next certified letter out, because otherwise you'd have to kick it back down to management. We don't recommend that. But on the original delinquencies that we're talking about, it does make a lot of sense, I think, to have the certified demand come from the manager. Certainly, some management companies may not be comfortable with that. Some boards may not be comfortable with that, and that's fine. The lawyer can do it. But I've given some good reasons why I do recommend it. At that point, once you have made your certified demand letter, again, 30 days on condo, 45 days for HOA, then you're ready to lien. Now, regardless of whether you intend to foreclose on property, and we're going to talk about that in just a moment, certainly it makes sense to file a lien against the property. And let me tell you why. Because if that owner tries to sell that property, you have two ways to put the buyer on notice. Number one is the power of your estoppel, right? So they have to get an estoppel letter. There's also another way, which is the more correct way, which is to file a lien against the property. Then when the title company runs a search on the property well in advance of the closing, they see an amount due to you, and they need to go ahead and pay that amount in order to issue a clean title policy to the buyer and allow the unit to be conveyed cleanly. So it is very prudent. It's also putting the lender on notice, putting judicial purchasers on notice, and that's a good point right there. Although a buyer of a transaction must get an estoppel, a judicial purchaser, as you may know, does not get an estoppel. They buy it through an auction. Now, how do they know what's owed to you? They don't. The lien would be the correct way for them to at least do some due diligence as to the amount owed. Now here's the good news about liens, is even assuming you're a condo where your lien is expired, and liens do expire once a year, we refile them for condos. HOA, they don't expire, but regardless, at that point, whether you liened or not is the point, the amount still is due to you. So that's some additional assurance to you that even if the lien expired, for example, on a condo, and all of a sudden you turn to your attorney and say, well, wait a second, the lien expired, we're all in trouble now. No, you're not. Okay? The amount is still due as a charge against the account, regardless of whether the lien was filed and regardless of whether the lien has expired. Okay? But it is still prudent to put the lien on the property, to put the world on notice that an amount is due to you. And of course, the most important reason to file a lien is because that is what you are technically foreclosing on. You're foreclosing your lien. So if you don't file a lien, then you don't even have the option to file a foreclosure. And so it is prudent to at least always consider and have that option available to you. And in most cases, as I'm going to elaborate in just a second, file the foreclosure against the unit. But before doing that, we want to look at other ways to get the association paid. And one of the new ways in the law, which is something that our firm actually worked on and innovated through a receivership program that is no longer needed, because now we have in the statute, effective as of 2010, the right to demand rent from any occupant living in a unit where the owner has failed to pay the assessment. And that's a very important right. The idea behind it was that during the peak of the recession, the audacity, not only did owners and speculators and investors stop paying assessments, but then they would siphon all the income off the unit through their tenant, so they're actually making money on the property while they're not paying the obligation, and while the tenant lives in the unit. So we stopped that initially by using a receiver, but then through legislative action, it was embedded into the statute where now you have the right to make a demand for the rent to be paid directly to the association to cover the full balance due to you through the full amount of rent, not a portion of the rent equal to your assessment, the full rent payment to be applied to the ledger. And what's interesting about that is we're not taking the owner's rental money. We're forcing them to be responsible in applying that rental income to the liability that they have against their unit. And ironically enough, it's a way that you can even potentially avoid having to file foreclosure or completing your foreclosure, which of course benefits the owner by simply forcing them to responsibly apply the rental income to the balance due on the unit. And the statute provides a very strong remedy if they fail to comply. You can then move forward with an eviction against the tenant if they refuse to comply with the rent demand. And so you will stop that income from going to the owner one way or another, if not by force on demand of the rent to be applied, then you will be able to evict the tenant. And on that note, I should emphasize, you would not be a landlord of the unit. You have no liabilities over the unit. You simply have the legal right now to demand that rent. And that has really paid dividends to our clients over the years. And so I'm going to take the questions at the end if I can, just because that rental income in most cases could be as much as maybe 2 to 3 or more times the amount of your monthly assessment. So even if they're behind by a year or two, in some cases, you know, if you're looking at a multiple or 3 or 4 times on the rent, you may be able to actually recover the amounts due to you within a fairly short period of time. But you have to act on that quickly. So management is typically our eyes and ears as to knowing whether there's an occupant in the unit. Legal should then make the demand on them and pursue the eviction if necessary. And so that's a very strong remedy. And look, let me also say, you know, before proceeding, our goal as the attorney for the association, of course, as the board of the association or management of the association, is not push people through to foreclosure. It's to get the association paid what it's owed and move on. So, you know, we're not guns blazing towards foreclosure. You want to be able to exercise any and all remedies ahead of that if possible, and the rent demand is an excellent first step. And also one thing to note is, you know, a lot of times we hear, well, we don't know who the tenant is, or we don't have the lease agreement. But what's interesting about the wording of the statute is you don't need to. First of all, they use the word occupant. So unless no rent is moving from the occupant to the landlord, which, sometimes they say it's a relative, it's a friend, there's no rent, and those are the trickier situations. You can still proceed in ways to try to discover whether that's true. But generally speaking, the point is that if you don't know who it is, make the demand anyway. Because you'd be surprised, you may get paid regardless of whether, in other words, I've seen a lot of boards not attempt that process because they're not sure who it is or they don't have a copy of the lease agreement. You should make those demands because they work, because the law affords you that right, and it's very effective. So I put this in our outline today before foreclosure because you should look before you file foreclosure whether you can get paid through rent. But if you can't, then you need to foreclose. And so what will foreclosure bring you in this market? Well, you're talking about parties who, in many cases, have abandoned these units. Strategic foreclosure, they call it, meaning that the owner basically defaulted on purpose or what have you because they're upside down. So the days of it being easy to collect dollars are far behind us. Frankly, in a good market, most people paid. And if they didn't pay, then the equity leverage that they had in their home, most people's biggest investment is their real property, whether it's their primary residence or an investment. And if they have any equity in the home, then once you place a lien on them and you threaten foreclosure, most of them paid. They don't want to lose their equity. And worst case, if they didn't have equity, you'd move forward to foreclosure, if they didn't pay rather, and somebody would buy it at a judicial sale. That's the way it's supposed to work. Unfortunately, that stopped in about 2006. And I can tell you that high percentage, 95, 99%, somewhere in that ballpark of units that went to foreclosure sale for associations, nobody bought them. Why would they buy them? The mortgage still affects the property. The property's upside down. That's why the owner didn't pay in the first place. They don't want to buy those kind of units. So it got a lot tougher. So foreclosure became even more important, though, despite the fact that you may not get paid at a foreclosure sale, because you get the following benefits. Number one, banks, at least in the past and still to some extent today, give their borrowers way too much breathing room. They don't want to take title to an upside-down property. They're not in the business of owning real estate. They weren't prepared for the onslaught of foreclosures and defaults that these banks have faced. And so when you look at the bank's position, I think there were published statistics that here in Florida, the average time frame was something in the ballpark of 800 to 900 days for foreclosure, and that's the average number. We've got cases where banks take 4 or 5 years to foreclose. And so the point is, the bank is giving the owner a ton of breathing room. If you're not proceeding against them, you're also giving them too much breathing room. And so filing foreclosure, for those who will pay, and I will emphasize that, certainly somebody who is abandoning the property may not be concerned initially about the foreclosure, but for those owners who want to keep their home, but the bank's giving them a lot of time and room to pay, your foreclosure against them finally gives them that legal ultimatum that the clock is ticking and they only have whatever it will take to complete the foreclosure, maybe 6 to 8 months from the time you file, before they'll lose title to their home. In other words, the low-lying fruit, the owners who would pay you but for the fact that there's no legal pressure, or at least no serious legal pressure on them, will pay if and when you file foreclosure. And that's what we proved, and that's what we found by filing those foreclosures. Any owner out there comes to the table at that point. That's when they wake up. That's your first benefit. Number two, filing foreclosures also puts pressure directly and indirectly on the bank. A lot of what's going on out there and has been going on, as you've seen, are short sales. Well, banks, sometimes they're in the mood to approve a short sale, sometimes they're not in the mood to approve a short sale. Sometimes they take a month, sometimes they take a year. It's the same concept. When you're foreclosing against their borrower, the clock is ticking on the bank's opportunity to conduct a short sale. In other words, once you foreclose out that owner, there is no short sale opportunity, and the lender realizes that, and they recognize that. And so it's not quantifiable. But I will tell you through our vast experience in the area that we see that when you're filing foreclosures, lenders are typically more inclined to approve a short sale that you may be hoping for. And short sale, by the way, is one of your best legal scenarios out there, because although there is the poker game, I call it, where they try to negotiate amounts with you and maybe you settle down a few of those amounts, legally, the full amount is due in a short sale. And so that's a great legal scenario. That makes you whole. So you like short sales. But is the bank going to approve it? Well, with the foreclosure filed against the owner, I would suggest they're much more inclined to do so. And there's another benefit on the bank side. The bank is also, we see, speeding up its own foreclosure when we're filing foreclosure, because now there are two competing foreclosures to get to the finish line, whereas if the association's not foreclosing, then the bank has no pressure on it. So you get the benefit of the bank's actions through your own foreclosure. And then, of course, although, as I mentioned, at the peak of the recession, very few units were bought in association foreclosure sales, I'm more pleased to report to you that according to our internal statistics on our portfolio, which is statewide, and in the thousands of cases per year, that about 33%, about 1/3 of the time now, an association foreclosure sale will go through to a judicial purchaser, at which time you'll get paid in full, the way it was supposed to work. And we see that the trend is heading in that direction. Less banks are taking title to their own units at foreclosure sale, roughly 40% right now in our internal statistic. About 1/3 of the time, as I just mentioned, association sales are now getting purchased by judicial purchasers. That, of course, is directly a result of the improving real estate market and the values out there. And we hope that as the market continues to improve, that trend and those statistics will continue to rise. So it goes back to the normal market, the normal plan of foreclosure will get you paid, which is the way it was supposed to work. So you need to foreclose diligently against the unit owner, all right? Ideally, and lawyers charge a lot of different ways for foreclosure, and certainly that is one of the dilemmas, is throwing good money after bad, paying legal fees for an amount that you're already due. Our firm in particular innovated a deferred fee model, where our clients do not pay legal fees up front or along the way. It's a balance due, just like your balance due. And when the file closes, we look to the responsible party, meaning the owner or the successor in the title or the bank, and I'm going to talk a little bit more about that, to pay the legal fees in addition to the full amount due to the association. And so that allowed our clients to really put the pedal to the metal and get serious about their delinquencies and their foreclosures, because they didn't have to contend with the upfront or along the way legal fees. Even assuming your lawyer will not agree to that, they still should be at the very least recovering their legal fees at the end of the case. And you should be reimbursed those legal fees. So in other words, it should be an advance of legal fees, but not a payment of legal fees netting out of the amounts that you recover. All right? And when I talk about foreclosing diligently against the unit owner, what does that mean? That means not taking unnecessary steps, not letting your lawyer over-lawyer the case. We've seen cases where lawyers are filing motions, they're going to trial, they're trying all sorts of different things. That's not really the way it works. It's a very, very straightforward and simple process, okay? You file your complaint. High percentage of the time, 95+% of the time, no answer is filed by the defendant. You enter a default. You move for summary judgment. You get your judgment. You go to foreclosure sale. There's not much more involved, okay? So
the other side, the owner in that case, knows the game, and he goes and files with the court without even letting our attorney know, and the process just gets delayed and delayed, back and forth.
let me take the questions at the end. Certainly there are some con artists out there who know how to work the system. Very small minority. There should be nothing where your attorney doesn't know, because it's all in the court records. And there are ways to sift through that and address it. But I would tell you, I said 95%. I think it's more like 99% are uncontested in foreclosure. This is not your normal civil litigation, other than that one guy you're talking about, and they are out there, I understand. But I'm talking generalities here. You don't take a number of extra steps because you're trying this, you're trying that. Of course, lawyers are making fees along the way. So it should be a pretty streamlined process according to what I just talked about. And that's why I'm talking about foreclose diligently against the owner, okay? Because the process is inherently slow. General time frames, we talked about waiting 30 days perhaps. You got a 30 to 45 day first certified demand letter, so another month and a half. Then you need to provide them with the lien and a second certified. And the second certified demand letter on condo is 30 days, HOA another 45 days. Once you've done that, you can file your complaint. So you're probably at 4 months realistically, if not 5 months, before you're going to be eligible to file your foreclosure. Now, I would suggest to you, if the owner hasn't come forward at all in those 5 months, again, you need to seriously consider filing foreclosure because they're not paying. They've had plenty of opportunity, 2 certified notices, coupons, other efforts by management. So when you file your foreclosure, you file it. You have to serve them with it, which is a variable. Finding them sometimes is tricky. If you can't find them and serve them personally, although that's recommended, then you can go ahead and serve them constructively by publishing it here in the Tri-County area in the Daily Business Review or the other publication in the market. And then that has to publish for 30 days. Once that is published, then you can go ahead and proceed with the default, which takes a hearing. And then at that point, then you're going to go ahead and file your summary judgment. You're going to get another hearing. And these are variables depending on the judge's calendar, the backlog in the judicial system, depending on which county you're in. And at that point, once you get your summary judgment, you need to set it for sale. Typically another 30 days, could be 60 days, depends on the market. When you add all that up, diligent means about a year. And that's why I started with the idea of start early and be diligent and expedient, because any detours you take along that road could turn into 2 years. And again, you're just more and more exposed to the delinquency the entire way. So you need to foreclose diligently against the unit. But we also, as I started before, want to be reasonable with the owner if we can, because our goal is not to take their home, the goal is to get you paid. And so you're going to see that along the way, there are opportunities where the owner comes forward and says, I can pay, but it's too much money now. Now, of course, that's their fault, that the late fees and interest are on there, that the attorney's fees have accrued, but that doesn't mean that the association board can't consider reducing penalties, that is, not assessments, and I'll talk about that in a second. Now, if you are going to reduce penalties, late fees and interest, and we do encourage our clients to at least consider that. Those are business decisions. Again, the law doesn't dictate that, so you have latitude, but you should do it uniformly. So don't do it for the one person you like, and then the next person you don't like, you're not going to do it. Everything that is done generally within the law of associations, you strive for uniformity. Keep that in mind. If you're going to give it to the first guy, then you should be prepared to honor it. Or even if you aren't going to honor it, the next guy, it's got to be a clean break that going forward you wouldn't honor it. In other words, it's a change in policy, but you don't pick and choose, the people that you want to help. Additionally, I can speak for our firm that we reduce our legal fees in our discretion every day to help homeowners help themselves and to get our clients' files closed. Because we're not going to be stubborn when we have an owner on the line trying to get out of delinquency, and we understand that legal fees are expensive, and so we have a volume practice. We look for long-term relationships with our clients, and we want to help our clients' members if we can. And I can tell you, every single day, we reduce our fees at our discretion, just like you may consider reducing your penalties to help homeowners help themselves. And hopefully, your lawyer considers doing that as well. Additionally, you should consider offering payment plans. Now, there's a lot of, strategy to payment plans, of course. The longer the payment plan, generally the more likelihood of default. So we don't encourage long-term payment plans. But again, another decision to be made by your board on what you think is reasonable and how you can help your member help yourself and in turn help your association. Generally, we do 3 to 6 month payment plans. Certainly we do 1 year. We've made exceptions past the point. We try to minimize the fees and penalties during the payment plan as well. Obviously, they're working backwards if more fees are accruing while they're trying to pay off. You certainly need to monitor those payment plans very carefully and not let them trick you, so to speak, or default on you where you're not cognizant of that, and all of a sudden months and months start flying by without recognizing that they're in default. So our firm typically will monitor that payment plan and make sure that if they do default, and it does occur, that you pick right back up on the case where you left off. But in the meantime, a payment plan is a great idea. And another obvious solution that we use that I presume other law firms also use, I'm not sure, is we have credit card capabilities. We have merchant accounts. Why would an owner who's facing a foreclosure against their home, who has an available credit limit on an unsecured credit card, not take that debt from the amount due to you that they're going to lose their home over and just put it on a credit card? Well, now they're facing a harassing telemarketer who's telling them they're late in their payment, not losing their home through foreclosure. So we've done an enormous amount of merchant services to get our clients paid through credit cards. And that's a very practical solution that works. So the point is that your association and your lawyer should be thinking about ways to get paid and close the file and not, push people through to the next part in the process. Let me speed up a little bit. Also in short sales are happening all the time. As I mentioned before, the full amount is due to you in a short sale scenario. But there's a little bit of the poker game, as I call it. They're going to tell you, well, if you don't approve the short sale, the unit will go through to foreclosure, the bank will take the property, you're only going to get 1%. So wouldn't you rather get 3 or 4 times that amount through the short sale by reducing some assessments and making a deal with us? Doesn't that sound good? Well, you know what? It does sound a little good. The problem is you're doing a little bit of speculation in the dark. Because what they fail to realize is, again, number one, the full amount is due, so the what if later is not applicable today. That's your cards to play. And secondly, how do they know it's going to go to the bank? I just told you only 40% in today's market go to the bank. Could be a lot less later. Judicial purchaser buys, you got paid the full amount. So that's why I call it the poker game, because you don't always know what your cards are going to be. But you got to also recognize there is some risk in that safe harbor 1%, and maybe 5 times your money now is better. So what we do, and that's why I started with, this is not lawyering in a vacuum or board governance in a vacuum. You really need to be looking at the status of that case. Where is the bank in their case? The lawyer should be able to tell you. How much is the offer? You know, is it just 2 times the amount of the 1%, or is it 10 times the amount of the 1%, but less than the full balance due? And so you need to be comfortable. And that, I would tell you, is within what we consider the business judgment rule, because what's interesting is the law does not allow you the right to reduce your assessments. There is not one spot in that statute giving you that legal right. Your documents say actually to the contrary, that amounts are due. The statute says the amount is due. It's only within this business judgment rule, if you can, because that's what this is. It's a not-for-profit corporation, but it's a corporation, that you really have to do what's in the best interest of the association at all times. So if you genuinely believe that it's in the best financial interest of the association to reduce some assessments, to accept a short sale because you believe that it may go to the 1% safe harbor, well then I would agree that you're acting correctly in the best interest, even though, again, it's that gray area where you really don't have an express legal right, is what I'm saying. All right, moving on. So go all the way to the foreclosure, but know whether the association can rent the unit first, we talked about, and see what the bank is doing before potentially taking title. One of the big issues out there, and we don't have a lot of time today to talk about the case, which our firm is the lead counsel on, but it's called Spiaggia. And all of a sudden, our battle has been with the banks for a half a decade. Now our new battle's with the judicial purchasers, again, because the market's improving, which is good news generally. Because the banks get the safe harbor. The judicial purchasers have to pay the full amount through joint and several liability. So now they're getting creative with their lawyers, many of whom have made mistakes to tell their clients they owe nothing when they took title through their foreclosure purchase. And then they get a bill for $50,000 from the association saying, oh, no, you do owe money, and they're making arguments. Well, the current status of that case, first of all, so you know, is the full balance is due to the association. At best, the judicial purchaser, once they tender that full payment, has a arguable right to come back on what's called an equitable contribution claim to get a piece of their money back, if any. Never the full balance, as there's a lot of confusion in the market that it's zeroed out, they owe nothing. Incorrect, at least as far as the status of the case today. And, but it is a new concern, which is, why would you want to take title to the unit if you can't rent it? You remember, the mortgage still affects the property. So you're not selling it, although some associations are actually delving into attempting short sales and accomplishing that. But generally, again, you can't sell it. So you want to kind of ascertain in advance, do you want to potentially rent the unit if you took title to it? A lot of associations make money through renting the units out after they take title. That is, again, if there's no occupant, you couldn't make the rent demand in the first place. When you take title to the unit, you are the legal owner. The bank still has a mortgage affecting the property. You don't have to pay the mortgage, by the way. You're not on the note. You have no liability. They will continue to foreclose on the unit. But you might have a lot of breathing room in advance of that to rent the unit out because of the stalling of the bank.
Under what circumstance can't you rent the unit out?
Well, if it's not in good condition. The question is, when can you rent it out? We've seen units in this kind of a recessionary market where people took the toilet, they took the sink, they took the fridge. I don't recommend associations invest real dollars, because again, the lender could foreclose you out at any time. But, clean up the unit, maybe paint it, some minor expense, yes. Major expense, no. And that's what I'm talking about when you can't, sometimes you can't rent the unit. If you can rent the unit, you should consider that. But talk to your lawyer, because you are then, at that point, unlike the rent demand, liable for anything a landlord's liable for. So on one note, you need to add it to your insurance policy for general liability. If the air conditioner handler goes out while you're the landlord, you're responsible for it. So you really want to think through the business liabilities. But generally, for a unit that's rent ready, especially in higher end buildings where the rents are attractive, and if the board is comfortable with those business and legal liabilities, then it does make a lot of sense to rent out the unit. But my point was, think about what you want to do with the unit before you complete the foreclosure sale, because if you can't rent it, what do you want it for? Now, I'm going to tell you probably the most important thing of the day, which is what you do if you want to have your cake and eat it too, basically. Okay? So we just covered this already. If the association can rent the unit, take the title. Okay? If the association cannot rent the unit, go through the sale process, but don't complete the sale. This is our latest innovation. It's the cake or eat it too that I just mentioned. You want to go through the sale process because, as I just noted, about 1/3 of the time you'll get paid in full. Hopefully, by the end of this year or next year, that'll be more like half the time. And if the market completely rebounds back to normal market price, it should be all of the time your units are purchased, not by you, by somebody at the foreclosure sale. That's how the whole process was supposed to work. But if you don't want the unit because it's not rent ready, how do you have your cake and eat it too? How can you go through the sale process but not take title? Well, what we realized is that, and by the way, the association takes title by becoming the initial bidder in the auction. You're required to initiate the bid at $100, which our firm advances for our clients, and you're the initial bidder. Nobody else bids, you took title. What's interesting is there's a very small period of time between the final sale and the certificate of sale and certificate of title actually being issued by the clerk of court, where you have to redeem the sale. You have to pay off. In other words, the bidders pay their down payment at the sale, then they have 24 hours to come back. There's a little bit of time where the association can look at whether anybody bid, but then not complete the sale and not take the certificate of title. So you can take your look, see if you got bought. If you got bought, great. You got paid. If you didn't get bought and you don't want title, don't complete the sale. And so I wish I had more time to talk about that, but it's been something that we've been doing in this county and the Tri-County area very successfully. It's a little innovative, but it's something that allows you to take a look at whether you get paid, but not take the liability of the unit if you don't. You need to have a really strong estoppel department today. I can tell you firsthand that the power of the voice and the advocate for you on your estoppel disputes is critical. More critical than the lawyering in the courtroom. Your lawyer's interpretation of the safe harbor bank cap, for example. Most firms take a conservative approach that only the 1% is collectible. Well, guess what? Their legal fees are probably more than 1%. So you probably got zero. You might have ended up losing money on the file. That doesn't make a lot of sense, and we don't think that's what the legislature intended. The 1% in the statute relates to the word assessments. But late fees aren't assessments, neither are legal fees, neither is interest. So our firm took an early approach and interpretation of that to say, okay, that's bad enough that you only have to pay 1% or 12 months, meaning the client can't collect over that 1 year. But I don't see your exemption for legal fees, so you can go ahead and pay that, and we've had almost 100% success with that over 10,000 times. So, and right now, to give you our current statistic, 2/3 of the time right now, banks pay our full fee in addition to your 1%. The other 1/3 of the time, my firm reduces an average of 27% of our bill and settles the file. We currently have 0 files being litigated over that issue, with 10,000 plus cases closed. So every lawyer out there who's not even demanding the late fees, interest, attorney's fees, and cost is leaving all that money on the table 2/3 of the time, and the other 1/3 of the time we're settling them down. That makes all the world of difference, because if you can't collect your legal fees, it adds to your net bad debt line item or your delinquency unnecessarily, because the legal fees were recoverable. And we are against bank counsel every single day, and it matters not only who's making the argument, but how they articulate the argument, and frankly, who the reputational lawyer is. It's not that big a business. We know the bank counsels out there, they know us. They have their lines, we have our lines. And we settle every single account for our clients. So our clients have not had that exposure of net losses, in addition to our deferred fee model that I mentioned, but you should be demanding those amounts. Additionally, these judicial purchasers, a lot of them are having their way on this Spiaggia case, which is not even a final case. We have 2 wins in lower court, a split decision arguably in the appellate court, going back up on appeal. The jury is out on this case, and we are in the winning column the whole way so far. And yet firms out there say, yeah, the association had title. No, we can't collect anything for you. Wrong. We're collecting it every single day. So in other words, the advocate you have on the phone for the estoppel is key. Even though the manager, on estoppels obviously deals with these issues, these are legal issues that need to be dealt with by your collection department. And you really need to understand what your lawyer's position is on these cases, because we see every day that associations are leaving a heck of a lot of money on the table because they don't have the right advocate on the phone when it comes time to the estoppel. And I can tell you, we have such little litigation going on over this stuff, because at the same time, as zealous as we are on this stuff, and innovative, we're conservative, and we're practical. We settle. We're not litigating it endlessly. We're negotiating it. And that negotiation benefits our clients hugely in the amounts they recover. I just have another couple minutes here, so let me speed it up again. Be prepared to pursue a second delinquent owner, which is the bank or the judicial purchaser if necessary. In other words, people think that just because the bank took title to the unit through foreclosure or a judicial purchaser bought it at a sale, you'll get paid tomorrow. That's frequently not the case. Then the bank sits right under your nose up in the unit as the owner while they quietly market it through the realtor, and they don't pay you for another 6 months or a year until it's convenient for them to come through at their final sale. You need to then file a demand, send another certified demand letter to the bank or the judicial purchaser, and we have many rounds of double collections where we have to foreclose against banks or judicial purchasers. And in fact, our firm's been successful, on First Service Properties, in fact, in foreclosing out the lender's interest where the association then owns the unit free and clear of the mortgage because the lender slept on its rights. We have extinguished mortgages by J.P. Morgan and others because they didn't pay. Now, more commonly, they will pay, but they won't pay until your lawyer puts it back through another demand, lien, and foreclosure, because otherwise, same thing with the owner, no pressure on them to act. So don't be so sure that just because it's sold at bank foreclosure sale or a judicial purchaser came through that you're definitely getting paid anytime soon. Now the good news and the silver lining on that is at least those amounts are fully collectible one way or another. The bank has no exemption once it took title for any amount due. But it's a timing issue. You have cash flow needs, you have operating needs. And what? J.P. Morgan doesn't have the money to pay your assessments? It's one thing for owners who have hardship, but let's get real here as far as what the lender's positions are. So be prepared to pursue a second delinquent owner if necessary. We kind of already talked about this. Know your legal options and the amounts that can be claimed from the bank or the judicial purchaser. I've covered those. Safe harbor interpretation and negotiation of that issue is critical these days because so many banks take title these days. Same thing with judicial purchasers. Don't let their lawyers outmatch your lawyer as far as their arguments of cases that are not yet final or that they're not versed enough in to make argument on your behalf, because these amounts are collectible and we collect them every day. Make sure to recover your attorney's fees, again, as I mentioned, in addition to the amounts due to the association. It is shameful, but we have seen, and it's gotten a lot better since we've been in the marketplace, but lawyers who charge you up front or along the way, and then they only collect your assessment. And a lot of times boards maybe didn't connect those dots because of the time or the way it was done, but if they didn't recover their fee in addition to your assessment, they took their fee out of your assessment unnecessarily because both your declaration and the statute are clear that you have the right to recover your attorney's fees. So there's no reason for that, other than the lawyer's not making the best effort or the board's not cognizant of that issue. So again, if not deferred, you should be recovering your legal fees through the process each and every time, with the exception of that only that safe harbor situation, and even then, if your lawyer's good enough, you likely will have no liability for those kind of cases either. So make sure to watch that you're recovering your attorney's fees on the file. This is where the future of these delinquencies is going. It's a little known right because it was never this bad in the marketplace, but you have a right to pursue the prior owner for a deficiency judgment on the amount that is left behind by the bank. When that bank only gives you 12 months 1%, there was a right in the statute that said that the owner was personally liable, like a guarantor on a note, for all amounts that accrued during your period of ownership. So, you got a building where $50,000 is due and you get this measly $3,800 check from the bank. Guess what? That money's still collectible from the prior owner who thought they strategically foreclosed, turned in the key, and walked away. And we're pursuing those, and we're getting them. Okay, so don't forget about those dollars. Those, yeah, they may be temporarily marked as bad debt in your books, but they're not unrecoverable. And our firm is offering contingency fees to do that kind of work because, again, the only question is the idea of throwing good money after bad, and that's a real question. So we're going to do it on a contingency basis so that associations have no qualms or risks about pursuing those prior delinquencies. And sure, maybe you give up a bigger share of the firm because we take the risk of our time and effort, but don't forget about that. Now, the key to that, by the way, and I forgot that when we were talking about foreclosure, here's another benefit of filing foreclosure. We include a count for money judgment in the foreclosures we file. Once we serve that owner and we get to the point I'm talking about, the bank shorts you the money, we don't need to sue the owner again. We go right for a motion hearing on a judgment against them because we already served them and litigated it and they defaulted. You record that judgment in the public records, they're good for 10 years with a renewing period of 10 years. And so, first of all, you can pursue garnishment of assets and wages. You can seize bank accounts. You can seize any non-homestead property or other assets they have. And even if you aren't pursuing assets because let's say they have nothing and some people don't, well, guess what? Next time they go to the credit market for a credit card, a car lease, a home loan, that underwriter is going to tell them to pay your association the judgment that was recorded prior in time to their credit. And those monies are going to come in. So don't leave those bad debt balances on the table because they're fully collectible. Now I'll take a few questions and answers and we'll wrap up. Yes, ma'am. Okay.
It's not very often done, but considering today's economic situation, if you're at the beginning of the year, is that a good thing now for condos to follow through in their documents?
Okay, the question is about whether to accelerate the balance due if given the right under the governing documents. Interestingly, I don't see a lot of associations doing that. I'm certainly familiar with the right that you're talking about. It's not a bad idea. Listen, banks do it. Anytime you default on your mortgage, you get notice of acceleration. They're not pursuing your monthly amount or the amount, they're pursuing the full loan. I don't see it done a lot. I would have your attorney review the right. If in fact it's confirmed the way you state, why not? Again, I would recommend doing it uniformly, of course, because you can't pick and choose, but why not? Listen, a party who's in default is your most likely candidate for future default. And that's why that right is in there, is to provide you with additional assurance going forward. The only reason it's probably not done is because a lot of these owners, in practicality, can barely pay in the first place. So to accelerate them and collect in advance on the year only pushes them further down the road of delinquency. If you could get it, though, or certainly if you could demand and recover it, then you should do it. But practically speaking, in today's market, it's probably very difficult. No, you'd have to notice on the acceleration first to claim the amount due, and then it would be the exact same process we talked about. Here we have less than 5 minutes. Let me take a couple more questions.
Two questions. One is, at auction, can you close on a property without an estoppel agreement with the association?
At a judicial sale? Yes.
Then what liability does the new owner have to the condo?
100% jointly and severally with the prior owner.
All right. Wow.
Which is why there's a lot of mistakes being made out there, which is why some of these judicial purchasers are getting creative with their lawyers to try to figure out ways to avoid it.
All right. But as part of that, the association took title, say, 2.5 years ago. It's gotten the rent.
Mm-hmm.
The rent's been applied as rental income.
Mm-hmm.
And the attorney is requesting a reconciliation or a statement showing and forcing the condo association to apply the association fees and not 100% of the rental income to rental income.
The rental income should be applied as a credit to the benefit of the successor on the ledger.
Okay, so
It does not change your...
the owner gets the benefit of that.
Yes. The question is whether you should, or in his case, whether they're applying the rent that is received through the rent demand or even your period of ownership, let's say, to the ledger. And my recommendation and advice is yes. First of all, it doesn't change your cash flow position at all. You still have the money to work with. It does credit to it. Yeah, because, listen, there are very few...
You still go back against all the previous association fees that were due plus interest and...
It should be applied to all those amounts. And let me tell you...
I'm getting a different opinion.
There's no reason not... First of all, there's no reason not to.
Well, you've got the Aventura case that...
That's our case.
All right, well, the association, but that was only with homeowners associations.
No, that's a condo. You're talking about Spiaggia Aventura Management?
Yes.
It's a condo case. It's a First Service ALG case.
That was the case that's being cited that would not enable the condo association to be able to get the new owner.
The current status of that case is 100% is due to the association. There's a lot of misinformation about it. I'd be glad to speak with you after and give you my card. Let me just make one quick comment on that, though. There are very few legal defenses in foreclosure. Bankruptcy, challenging the validity of the debt. That's it. If you don't apply that rent to the ledger, you've given them one more. Failure to mitigate. You're giving a lawyer an opportunity to say, you guys have acted inequitably. You took money on the unit, you didn't apply it to the ledger. In other words, you're in for unnecessary litigation. In equity and fairness, money that yields off the unit should be applied to the ledger. That should be to the benefit of the successor in title. Any balance that is still remains should be collectible against them, but we strongly recommend to apply that rent. Yes, sir.
You mentioned something about go over into foreclosure and then pick up in the 24 hours. So let's say you do that.
Well, wait, the question is about how to proceed at the point of sale. I said if you don't want the unit, right, if you want the unit, you complete the sale.
You decided that the unit is unrented.
Yes.
You go through the whole
Yes.
thing and then you back up within these 24
Right, you don't close on the unit, basically.
So what is the difference? What do you get?
Because you didn't know until you went through the sale whether you were going to get paid. You only found out a moment after the sale that nobody bought it. So if you don't go through the sale process, you don't get to see whether you're going to recover. But once you got through that process and you didn't recover, you don't want to take the title to the unit, you cancel the sale.
Okay, but why
Because what can you do with it? And then it becomes the Spiaggia case, which is complicated, becomes a legal and business liability. You have no benefit is the point.
Why jeopardize your rights because you took title?
Well, it complicates the legal rights, but the real issue is you have no economic benefit. You're not going to rent it, which was the decision we were talking about making, and you can't sell it practically because the lender still has a
Negotiate now with the bank.
You can, and that's another decision to make before going through to see if you want to take title. But very few associations so far have been successful in short selling because it takes a lot of effort, time, energy, and expertise. It is technically possible. We've seen it accomplished, but not in a widespread way.
And what happened if you took title, you thought that it's rentable because somebody was living there, they lost the property, you serve a demand letter for them to evacuate 30 days, blah, 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 they stretch it a little bit, a few minutes before the sheriff got on, they left, you open the door,
Yeah, I'll tell you what, I'm sorry. I got notice that it's time to end the class, but I will stay after, answer any personal questions, including this, and we'll continue the conversation. Thank you very much for your time, and I hope you enjoyed.